Mr. Butler.
Thank you, my lord. My learned friend, Mr. Tabori, I think has just handed up an extract of the single competent authority file, which the court asked a question about. I've only just been handed a copy, so I'm not sure I can take the court through it, but I'm told that there is a minute of the SCA's decision on the conclusive ground stage, beginning at page 33.
Yes, I see. So,
Have you never seen it before?
Well, no, I will have done, but I haven't looked at it today before. Before a couple of minutes ago.
So, how would you propose that we deal with this?
Well, I'm inviting the court to proceed on the basis of the judge's findings, and not to have regard to extraneous evidence, still less evidence that was in respect of which an application was made below to admit, and the judge refused.
I think what we might do then is put it on one side for the moment, allow Mr. Tabori to seek to persuade us that we should be interesting ourselves in it.
Yes.
Then if we are so persuaded, we can come back to you in reply.
Yes. Just on that point, my lord, I might just ask the court to note that at page 40 of the core bundle, there is a postscript, paragraph 65 onwards.
On the judgment, yeah.
In the judgment, yes.
Basically saying you can't rely on this.
Exactly.
And you would no doubt point out there's no respondent's notice.
Exactly.
If they had wanted to rely on it.
Yeah.
So if I might pick up, I think roughly where I left off. We say that if one applies the Osmond test, which we say is the applicable test, then in my submission it was plainly reasonable to expect the local authority to conduct a lawful assessment under section 47, and as part of that, as the judge held, to liaise with the police and a single competent authority. It really is as simple as that. And one could also look at it another way and say that complying with obligations imposed under domestic law could hardly be said to impose a disproportionate burden for the purposes of Article 4. So we simply say that the local authority didn't do all that could be reasonably expected of it to protect the claimant from trafficking. Now, the court has my point that I say I don't need to establish that the claimant suffered loss as a consequence of that breach, but could I just ask you to note some of the material, because I wouldn't want you to be left with the impression that there were necessarily no adverse consequences. If we could look in the supplementary bundle, please. At page 44. What we've got here is an email chain that was exhibited to a witness statement from Rebecca Francis, who is a solicitor at GARAS, which stands for Gloucestershire Action for Refugees and Asylum Seekers. And it's an email from her to Portia Manessa, who at the time was the allocated social worker, Swindon's allocated social worker. And if you could look, please, at page 45, the second and the third paragraphs. Last night, 22nd of July, 2020, H called me at about 10 to 10 p.m. in a very distressed state. He said he was very sad and seemed to be tearful. He said someone had been in his flat and stolen £1,400 in cash, some clothes and trainers, and his Home Office letter of status. He said he was very scared he would be attacked and killed. And then just by the second hole punch, there is a sentence which begins, "There is considerable concern for his safety," that he is being used by those involved in illegal activities in Gloucester, particularly, for example, county lines and fake cigarettes, perhaps to store items for them. Clearly, if anything has gone missing, he may be at risk of punishment or indebtedness. I'd be very grateful for anything you can do to improve his safety and move him to a more appropriate and supported placement. So this is 23rd of July 2020. And then Ms. Francis, the author of that email, gave an updating witness statement, which we've got at page 49. Dated the 16th of October 2020, and she describes a meeting that she attended with the claimant and the allocated social worker. And one sees the end of the second line on page 49, Portia, the social worker, asked him what he was afraid of. He told us that the money that was stolen from his flat wasn't his. Someone asked him to keep it in his flat for a few days. That person now wants the money back, and H needs to give it to him. He's afraid of what will happen if he can't. Now, I don't ask the court to make any findings. I don't ask the court to find that the appellant suffered harm as a result of the Article 4 breach. But as I say, I didn't want to leave the impression that complying with the protection duty wasn't important in this case.
And what did the police do? Because if you read the email, it says the police are going to come round to the flat.
I don't know the answer to that. It was the community police rather than anyone who seems to be involved with trafficking, but I'll take instructions.
It says in paragraph 6 of Rebecca Francis' statement at the end, how much has been in touch with these same officers recently after the burglary at his flat in July 2020.
I'm so sorry, my lord, which?
Sorry, page 48 of the file.
Yes.
Last sentence, the appellant has been in touch with these same officers recently after the burglary.
Yes. Yes.
And do we know what happened about paragraph 7? We end up with it being said that we discussed how his flat could be made safer, e.g. CCTV on the outside or inside of the door. Portia is asking key 2. Do you know what happened?
No, we don't. I did make inquiries as to what the current situation is.
Yes.
And he remains at the same flat, and as I understand it, with no additional protection measures in place. There is no record of any discussion between the local authority and the police as to measures that might be put in place. And there has been, although there has been a pathway assessment now that he's turned 18, that doesn't grapple with the question of trafficking risk and so on. I think really the point is that one can't say with any confidence that this is all historic, this is all water under the bridge. I say no more than that about it. So that was my third topic. I then turn to my fourth and final topic, which is to address the question of which state agency is responsible for protecting child victims of trafficking. And I absolutely take my lady's point. That the judge may not have intended to suggest that police and a single competent authority were principally responsible, but given that that's at least one reading of the judgment, and as my lord pointed out, that local authorities will no doubt be looking to the judgment to identify their obligations, I do want to, if I can, to just deal with this point. So there is one Act of Parliament which specifically governs child protection, and that's the Children Act 1989. And that Act is supplemented by statutory guidance, and that statutory guidance makes it clear that the Act also governs the protection of children from modern slavery. There is nothing, we say, no legislation, no guidance, no case law, suggest that the police or the single competent authority have principal responsibility for protecting children from modern slavery. And so if that's how the judgment should be read, then the judge was wrong to say what he said. Could I begin, please, with the Children Act, which is Volume 1 of the Authorities, Tab 2.
While we're turning that up, is it right the single competent authority is part of the Home Office?
Yes.
Yeah.
At the time of the judgment below, there was what was called a single competent authority. There was only one of it. Since then, as you can see in the latest iteration of the statutory guidance, it's been split up into different competent authorities, but I don't think we need to worry about that. But my Lord's right, it's part of the Home Office. Page 16, if I may. Section 17, subsection 1, as the court may know, imposes a general duty on local authorities to safeguard and promote the welfare of children in their area who are in need. And there is a definition of children in need overly at subsection 10. That is the umbrella assessment duty. And then we've got a more focused assessment duty, the section 47 duty, at page 139. Where there is a risk of significant harm. And I don't propose to take the court through that now, given that we've already looked at it in the body of the judgment. But what I did want to show you was the proceedings section of the Act. I'm so sorry, section 47 was at page 139. Yes. The proceedings section, section 46, is at page 136. And this identifies the role of the police in child protection. And in summary, what this does is to give the police a stopgap power to protect a child for up to 72 hours until the local authority can take over.
Sorry, section?
Section 46.
Thank you.
Page 136. And so one can see the threshold for the police obligation at section 46, subsection 1, where a constable has reasonable cause to believe a child would otherwise be likely to suffer significant harm, he may remove the child to suitable accommodation and keep him there. And then subsection 3b, as soon as reasonably practicable after taking a child into police protection, the constable concerned shall b, give detail to the authority within whose area the child is ordinarily resident, which is then defined as the appropriate authority of the place at which the child has been accommodated. And then overleaf, subsection 6 makes clear that the police protection power lasts for a maximum of 72 hours. And then subsection 7, the protection period can be extended by making an application to the court on behalf of the local authority. There's a reference to section 44, the power to seek an emergency protection order. And we've got section 44 at page 128. So it begins at 127. The bit I wanted to draw the court's attention to is subsection 4 on page 128. While an order under this section, an emergency protection order, is in force, C, it gives the applicant parental responsibility for the child. And as we've seen, the applicant is the local authority. It's taken to be the local authority. And so the police's statutory role, in my submission, is limited to emergency response and then handing the child over to the local authority, which then picks up the reins and has to do the risk assessment and safeguarding under section 47. And that's made even clearer by the working together statutory guidance, which the judge referred to. And that's in this same bundle at tab 8. If the court would please look at page 282. We see a convenient summary of the local authority's statutory duties. And then if the court would please note the penultimate bullet point, which relates to section 47. And if I could draw attention to the last two sentences of that penultimate paragraph, it reads, such inquiries, that is section 47 inquiries, supported by other organisations and agencies as appropriate, should be initiated where there are concerns about all forms of abuse and neglect. This includes ... criminal exploitation. And then, if I may, page 285, paragraph 40, line 6, again makes it clear that those local authority statutory duties apply to risks of criminal exploitation, and it specifically references trafficking.
Sorry, which page is that?
Page 285.
Thank you.
Paragraph 40. Line 6.
Yep.
And then page 305, we're still within the same guidance document.
Sorry, which page?
Page 305. This sets out what the section 47 process requires, and it's these passages which the judge cited. And one sees the purpose of section 47 inquiries on page 305. Purpose, the section 47 inquiry is initiated to decide whether and what type of action is required to safeguard and promote the welfare of a child who is suspected of or likely to be suffering significant harm. And then immediately above that, paragraph above that, one sees local authority social workers should lead assessments under section 47. The police, health practitioners, etc. should help the local authority in undertaking its inquiries. And that same distinction is then made under the following heading: social workers should lead, and overly, the police should help. Then page 307 is headed Outcome of section 47 inquiries. And the first sentence reads that local authority social workers are responsible for deciding what action to take and how to proceed following section 47 inquiries. And then page 308, heading where concerns of significant risk are substantiated and the child is judged to be suffering or likely to be suffering significant harm, then social workers should convene an initial child protection conference. And the requirements of a child protection conference are set out on the following page. And then page 311 provides that the child protection conference should result in a child protection plan. And one sees the purpose of that is to ensure the child is safe from harm and to prevent them from suffering further harm. And then under the heading social workers should, second bullet, develop the outline child protection plan into a more detailed interagency plan and circulate to relevant practitioners. So what I draw from this is that the local authority is the principal child protection agency, which should enlist the help of the police so far as required, but the buck stops with the local authority.
For a child in its area?
Yes.
For a child in need in its area?
There is then also specific statutory guidance for local authorities relating to child victims of modern slavery, and that's in volume 2 of the authorities. Tab 25. page 1088. If I could ask the court please to read paragraph 67. And then overleaf, page 1089, paragraph 70, provides that placement decisions should take particular account of the need to protect the child from any risk of being exploited and from a heightened risk of them going missing. Transfer to the care of another local authority or an out-of-area placement might in some cases be appropriate to put distance between the child and where their traffickers expect them to be. And that, in my submission, might have been of particular relevance here. Had the local authority obtained police intelligence that the claimant was at risk of Kurdish traffickers in the Gloucester area, it might well have been appropriate to arrange for him to be placed in a different part of the country. I'm sorry to skip around. Could I ask you please also to look at the Modern Slavery Act statutory guidance? That's volume 1. Tab 7. This is guidance that's issued under section 49 of the Modern Slavery Act. And if the court would please look at page 230. This sets out the functions of the competent authority. I don't propose to take the court through the passages of this annex. The point I want to make is that the competent authority is a purely decision-making body. It makes decisions, reasonable grounds and conclusive grounds decisions, based only on the papers and based only on information supplied by the Home Office and other agencies. And the point I want to make is that the competent authority has no operational capacity. And so it's difficult to see how it could owe an operational protection duty. Chapter 8 of the guidance and Annex F set out the support available for adult victims of modern slavery. Can I just give you the reference rather than turning it up? Chapter 8 is, I'm afraid, in the second volume. I forgot to include it with the main authorities. Tab 24, page 1026. And then Annex F, which accompanies Chapter 8, is the same tab.
Sorry, page?
Page 1026.
Yep.
And Annex F is the same tab, page 1034. Just to give you a summary, the protection needs of adult victims of trafficking are assessed by the Salvation Army and protective support, such as safe houses, are provided by the Salvation Army. And all that's done pursuant to a contract between the Salvation Army and the Home Office. The details of that, the way in which accommodation is provided, the amount of financial support and so forth is set out in the annex.
Sorry, can I just have that reference again? It's second volume of authorities divided 24.
24, yes. Page 1026. I hope I've got this right.
Because I've got A and Criminal Injuries Compensation Board.
Ah. I don't know why that's there. Have you got a page 1022?
There was a supplemental bundle
Yeah.
which had these extra authorities in it.
Which are separate. So there is in fact two divided 24s.
Ah, well, the
Anyway,
first
it doesn't matter.
24 shouldn't be in there.
I've got the supplementary bundle, and this is the modern slavery statutory guidance.
That's exactly it. I'm
Yeah.
sorry. That's
Fantastic. No, don't worry, because otherwise I'm looking it up later and then muttering about whether I've got the right reference.
Yes.
Thank you.
Child victims of trafficking are dealt with differently. They're dealt with in a separate part of the statutory guidance. They aren't covered by the contract between the Home Office and the Salvation Army.
Yep.
They're catered for by Chapter 9, this guidance, and Annex G. I'm afraid we're back to the first volume of authorities. Chapter 9 is at page 218. So I hope you see there, Chapter 9, Child Victims, the heading. And then if you could please look at page 220 in particular. There is a heading, Safeguarding Children. Now, I cited this in the skeleton argument, so it may be that you've already read it, but these are the passages that I wanted to draw particular attention to. And I'll ask the court at least to mark up paragraphs 9.13 to 9.18. And that, we say, makes it crystal clear that local authorities are the principal agency for safeguarding child victims of trafficking from further trafficking. And it makes clear, one sees that 9.15, that where the Section 47 threshold is triggered, as here, then the process by which children should be safeguarded is the Section 47 process.
You've got about 2 minutes.
Thank you. I think I can finish within 2 minutes. So we say the judge didn't explain what he meant when he said that the police or the single competent authority were principally concerned with protection duty. But even if the police, also, it's entirely unclear how it could be said that they owed a protection duty in these circumstances, but even assuming they also owed an Article 4 protection duty, we say that couldn't abrogate or diminish the local authority's duty to do all that could reasonably be expected. And as I've said, that meant at a minimum proactively investigating risk. Right. If I could just show the court one final reference before I sit down. I've suggested that if the local authority had found that the claimant was at risk from a Kurdish criminal gang in Gloucester, that they might have decided to move them out of area to keep him out of the gang's clutches or move them into more protective accommodation. Could I just show you, please, core bundle, page 215. This is part of the 4th of February 2020 assessment. And if the court would please look at the bottom of page 215, there is a paragraph numbered 2, where the social worker says, I appreciate that the supported housing, on the other side of a very fine balance, also could increase the risks of criminal exploitation. I'm sorry, I should say that supported housing here is the form of accommodation he was in. On the other side of a very fine balance, also could increase the risks of criminal exploitation due to lack of 24-hour direct supervision, and doesn't provide H with the nurture he requires to heal psychologically. And so, had the had further information been obtained from the police, we say it's at least possible that the fine balance might have been tipped. So as to result in a different form of accommodation.
But he subjectively wanted to go and live in a different part of Gloucester, didn't he?
He wanted to live in what appears to have been an unsuitable, even more unsuitable part of Gloucester. But he did also say that he wanted more protection in his current accommodation.
Yep.
And as I said earlier, of course, he would have received advice from those who were assisting him, other than the local authority, as to what he should take up if it was offered by the local authority. Unless I can assist further, there's my...
Thank you very much. Mr. Tabori.
My lord, my lady, I'll begin with some summary of our position on the two grounds. Then I will turn to a positive case, to the extent that responding is a positive case that will be in line with the skeleton and expand upon it. And then lastly, I hope I've still got time to respond to points made by my learned friend this morning and after lunch briefly. So broadly, this is an appeal against the Article 4 decision by the judge below, even though there was success already in relation to the Section 47 duty of inquiry. It is brought on two quite specific grounds. The first is a ground challenging a description of the relationship, the dynamics between the various agencies by which the UK discharges its international duties, essentially, the European Convention Against Trafficking and the Palermo Protocol, a UN treaty. And on that, as you'll see from my skeleton, we say primarily, despite the way it's formulated in the ground, this was a fairly innocuous and probably obiter description as to, in passing, about the relative roles between the agencies. But in any case, it was accurate. But perhaps thirdly, it was immaterial to the central conclusion, because whilst it was drafted in terms of the conclusion, one can see that though it was the last sentence in the main bit of the judgment for that postscript regarding late evidence, in fact the conclusion is in the previous paragraph, which is the previous sentence, which is the finding, I don't find there to be a breach. As to the second ground, this is the one that has become something of a re-argument before you today, but in fact permission was obtained on the basis of quite a specific point, which is essentially to say that it should have followed from the Section 47 decision that there should also have been finding a breach of the quite different Article 4 protection duty. And I'll start with the second, because that is the order in which you've been addressed by my own friend. The first point is that nothing should inherently presuppose that. And no authorities are cited for the same. Now, you are the Court of Appeal, and you're well able to change the law and say it simply hasn't been addressed yet. But I do submit that at the top of the list of my submissions, that is significant, because it is not as though this phenomenon of child victims of trafficking is new. And certainly there is voluminous case law from Strasbourg. Secondly, it is very important to note that the distinctions between the respective duties. Section 47 is a duty of inquiry. If it has any corollary and reach across to Article 4, the triptych thereunder, it is with the investigative duty. Yet, as confirmed by the Court's cite of the amended Statement of Facts and Grounds this morning, and indeed by the skeleton for this hearing, it is a protection duty that my own friend relies on and that has always been relied upon. and in the narrowest terms. Now, I want to get onto breach later, but whilst I touch on that aspect of the pleading, it's notable, I believe, my lord raised that the specific single instance of breach raised in those amended statement of facts and grounds was failure to notify the police in order that they may conduct their investigative duty. Now, that is as niche and precise as you can possibly imagine, but it is not the wide-ranging protection duty that you've heard submissions on. But above all, it also would fail on its own facts, or should have, though I'm not sure it was a point considered by the judge, because it is the case that, and one sees this from the modern slavery guidance, and from, if you want to consider it de bene esse, the SCA's clip of documents, that the SCA notifies the police directly upon its both reasonable and conclusive ground decision. The LA has no role, much less a Article 4 duty that would be breached without doing it, to convey the news to the police to ensure that they may do their job. So it deserved to fail on that count alone. But the second point in my list here is simply about the distinction, the great distinction between the two. And I would like to turn bench to the latest authority that exists in this area, but also in the authorities bundle. And this is less than a week ago, the Supreme Court's decision in the Crown on behalf of A and the Criminal Injuries Compensation Authority.
So is this the first divided 24?
Beg your pardon, my lord?
I think this is the first divided 24, isn't it?
Or it's
Mine
divided
comes at
26.
tab 26. My
Yes.
apologies. I don't.
Depending on which version you're looking at.
And page 1116 of the authorities bundle. So we will come back to this authority in relation to another crucial point that I can see concerned the court this morning. But at this stage, it is just to point out the also very recent decision of the Grand Chamber in SM, because it's usefully set out in paragraph 30 of Lord Lloyd Jones' judgment.
1-3.
30, my lord, sorry. 30. 1116 of the bundle.
Thank you. I haven't got the page numbers, but just paragraph numbers is great.
Okay. And the court there said, in general, the first two aspects of the positive obligations can be denoted as substantive, whereas the third aspect designates the state's positive procedural obligation. So that highlights to the extent these categorizations matter, that we are talking about substantive versus procedural investigative.
Do we have SM in Croatia?
We don't, my lord, but I can have it brought. I'm not going to look at it for anything else.
More than that? No. Okay, thanks.
And this is particularly relevant when one thinks about the issue of breach, because, may I repeat it, though I hope it won't become boring my repeating it. This is an appeal against a finding of breach. It is not a finding of that there was an error of law as to the scope of a duty as one often sees, because scope of a duty is obviously about the law, but a finding by a first instance judge as to what he considered the facts before him and the evidence available to him, which he was very circumspect about controlling, rejecting the further evidence, should be afforded a wide ambit on an appeal. And it is easy to see why breach should be found in relation to section 47 and not the protection duty. If a duty is engaged that requires inquiry and investigation, then once engaged, it's breached if there's no inquiry. But if it is something other than that, if it is a substantive operational/protection duty, the question of breach affords greater leeway. Hence, we have these descriptions, we'll come to see Rabone and TDT, regarding reasonable steps. This is something for a first instance judge to sink his teeth into and come up with a lawful decision. He has, but it means it is particularly difficult in reliance on Section 47 having been breached to say that it should follow in any way that the protection duty was also. On the same issue of breach, there is the question of threshold at which they are engaged. Now, this is only a somewhat discrete point because a key feature of this case is the court found the duty engaged. It's not about not engaged. But it is notable nonetheless just how low the Section 47 duty found to be breached, found to demand a very particular step to be taken pursuant to the working together guidance, namely strategy meeting, which wasn't done, hence breach, which was stressed by my learned friend's skeleton at first instance as being a, quote, deliberately low threshold. Easy to see why that was breached, and yet it not to follow in any way that the protection duty was also. At this point, I'm going to test the water as to the court's willingness to look at that SCA file. And its relevance is partly because it tells you the basis of the SCA decision. And de bene esse, you can just shut this out from your thoughts if you, at the conclusion. The decision was not based on any police information. It was based wholly on the local authority's NRM referral, plus some further information from the Home Office file, which led to the finding in the same conclusive ground decision that you've seen, that there was also forced labour in Iraq before he came to the UK, tied up with his asylum claim.
Let me just see what others think. Mr. Tabori, before we look at it even de bene esse, we can see that the judge deliberately shut it out. That's not something that's challenged by you. Is it in those circumstances appropriate for us to have regard to it, even de bene esse?
My understanding, as the more junior of the two advocates before you, that more limited understanding is that the Court of Appeal has that power. I don't want to problematise the conclusion or cause it problems. It's not a fulcrum of our case. Much inquiry was made as where on earth, what was the basis of this, given the police didn't find any evidence.
Well, why wasn't it adduced at first instance?
It was simply late. I mean, the point was made primarily.
Why wasn't there a request for an adjournment?
I think it essentially arose, if my memory is correct, from the way the judge decided that this inquiry of the SCA was a necessary step for purposes of Section 47, because our case had been, we have assessed risk, and the bench has seen the detailed assessment of exactly the same issues as to risk, which led to the decision, right, we need to keep protecting him via accommodation, via therapy, via healthcare support, to, as all the guidance demands, remove him from the situation. Doing it via Section 47 is by the by. The judge was entitled, we have to accept, to find that given the specificity of the working together guidance regarding Section 47, necessarily so it's not left to leeways of social worker discretion, to find that there had been a breach. But ultimately our point was that materially it added nothing. He nonetheless said, having received this conclusive grounds decision, you should have inquired about what was the basis of it in case they had any new information for you. And we're like, there's no chance of that. The police would have told us if there was new information. We are assessing him on all the while. So we obtained it belatedly, but I have to accept now, perhaps too late, but it confirmed that submission. But
if you
risk,
were
perhaps.
going to obtain it late, fine, we all understand how these things happen, especially if you're put under unreasonable pressure with an expedited hearing, or reasonable pressure for understandable reasons. But then why didn't you put in an appeal saying the judge shouldn't have excluded it, given the procedural history?
Because, my lord, as I say, we would have to accept that the Section 47, irrespective business of materiality of inquiry, is deliberately low threshold, to quote my learned friend at first instance, demanded a specific step be taken, strategy meeting, and it's not simply about
saying... Yes, but his appeal was on Article 4. You knew that, and yet you didn't cross-appeal and say, well, actually, if you're now going to open up Article 4 again, we want to put this in.
Because, well, I don't need it for Article 4 and the resistance to the appeal, and we would have to accept that it doesn't undermine the conclusion on Section 47.
Mr. Tabori, I think where we get to is, can you show us, so to speak, the punchline on a de bene basis? At the moment, it's quite hard to see how we can really take this into account in arriving at any conclusion.
Absolutely not. Want to open it and the long stick cautiously. Page 36.
Yeah.
So it shows that which was considered in relation to Incident 2 UK forced criminality. Olga Asmeyer from Swindon has provided a consistent account in the NRM referral in relation to exploitation you have or currently experience in the UK. HA has provided details. HA is also a social worker. Provided details of your movements and names of your traffickers.
Yeah.
So where is that in the social worker's files?
Do you mean, my lord, in terms of?
Well, in the bundle, we've got the core bundle, we've got the supplementary bundle. If your council employee has provided all these details to the Home Office, one might have expected it to see it with a duty of candour in your statement and exhibited to it all.
I believe the NRM referral was in the bundle at first.
Yeah, well, then where is it? Do you mind just showing us where these names are in the files?
I'm sorry, Lord, do you mean the names of the traffickers?
Yeah.
Or, yeah.
Where he's referred to it in the files. Because I've read obviously through the materials, but at the moment I haven't picked up those names, so I just want to know where they are.
Lord, I'm afraid I don't know immediately where they are set out, whether the NRM referral is in the appeal bundle, but I can obtain that also. Sorry not to be able to assist.
So the materials seemingly relied on were Mr. Alsmeyer, a psychologist's report, letter from Gloucester Aid, and consistency with US State Department report.
Yes, I'm not sure about how that one comes into it, but that's their decision.
Yeah.
Well, I imagine that the US State Department is on the earlier material back in Iraq.
Yes, which they do address in relation to Incident 1. I'm not sure why it repeats itself in relation to goings on in Gloucestershire.
No, that is a curiosity.
Perhaps, though, my Lord Justice Dingemans, I can't assist with where, I'm not sure we have the NRM referral. we do have the assessment that followed receipt of the conclusive grounds decision.
Which was the 29th of January, yeah.
Yes, exactly. Concluded 5 days later. And that goes into detail about, I don't think it gives you the names that you're perhaps after, my lord, but as to the extent of the risk in far greater detail than the SCA had. So there is clear knowledge and awareness of the extent of risk, and the relevance of this SCA minute is that there was no further update. That's all. That was the point below, and its relevance now is simply in relation to the question of whether the judge was wrong to find breach, and perhaps to limit the weight that should be attached to this question of inquiry of the SCA, because it simply bears out what we submitted was the position on the policy anyway, that because the SCA notify the police directly, the local authority doesn't provide this node position fielding everything in order to ensure a protection duty is discharged. It is a first responder along with many others. And of course it has child protection duties, but they are not coterminous, as we'll go on to say, with Article 4, the protection duty.
Well, if you can just help me then with the facts, because this is an appeal. He says the judge should have found Article 4 breach. You say not. At the moment, it seems that the whole procedure below was truncated unnecessarily. We are where we are. But if one looks at the 29th of January, page 9 of the core bundle, page 14 we get a bit more of the detail. For myself, I can't find anything that would accord with the social worker having reported trafficking.
Sorry, no, are you referring to the judgment?
Are you in the supplemental bundle, page 9?
Yeah,
of the supplemental
yes, sorry.
The assessment is in two places, isn't it? It's in the core and also the supplemental bundle, I think.
So it starts on the 29th of January, but is completed on the 4th of February, I think. Is that right?
Yes.
So where is there something that picks up what the SCA said they were told by the social worker, which you've asked us to look at de bene essay?
Well, I think the point is under safety on page 19 of the supplementary bundle.
Thank you.
Which you may want to read to yourself if you haven't seen it yet, going on to third down 20 as well.
And that's it.
That's it. It's not perhaps in the same terms as the NRM referral, but as I say, I can obtain that for you so you know exactly what was put to the SCA. But I'm not sure. I would say that's even less material than the fact of the SCA decision having been based on the local authorities referral. But if it assists, because you don't know better than I which way you are going, my lord, and perhaps it's key, I can obtain it.
Well, I can't help feeling provisionally that we're on an exercise of complete artificiality. If the claimant is saying we can't look at this for understandable reasons, you're not cross-appealing, and we're being asked to make at this stage a first instance finding of breach, where you say there's a complete answer to it, but you didn't put in a respondent's notice.
I wouldn't say it's a complete answer at all, my lord, because as I say, I would have to accept that the way that the statutory guidance is in its demand for this.
No, but this is an Article 4, not the Section 47 that he's appealing about.
Yes. Indeed, my Lord. I mean, its relevance is simply as to the basis of the decision being what was told, from which it might be found, if one's to consider this matter, that as to inquiry, there was no point, because it was the authority that was the one already on top of all the information, because it had made the referral as required, as distinct from all the Strasbourg authorities.
One might have thought that would have been paragraph 1 of the summary grounds of defence.
I think we have even better points, my Lord, but I might be wrong. Because Section 47 is not, and its requirements would not have been answered by saying...
No, we're not on Section 47. We're talking about Article 4, which is what his appeal is about. You're in breach of Section 47. You're not appealing that.
Yeah.
But you are responding to his Article 4. And you, on the face of it, say that you have evidence which would have been a complete answer to that. The judge excluded it, and you didn't even ask it to be put in on the appeal.
I don't say it's a complete answer. There are much stronger points than that. It is one that is relevant, because, as I say, we are talking about an appeal against a finding that of no breach. It was a relevant point, but I could certainly see that it was one that should have been foregrounded because of my Lord's view of it.
Thank you.
The third point in my list, we've spent a bit of a detour, so I'll just recap. One is the fact that nothing inherently leads from 47 to the Article 4 protection duty breach, much less any authority out there. 2 was that the discord between the investigative duty, that is Section 47, and the substantive protection duty, see SM Croatia, and the inquiry facts, which may have been problematic to have raised, but I thought it was helpful to illustrate the relevance of the facts vis-a-vis inquiry and this below. But moving on to the third point. The third point is that it is relevant where that we are talking about Article 4, which is part of this little coterie of the most important provisions. It is unqualified, like only Article 3. Even Article 2, I believe, has limited derogations. And that should give colour to the court's understanding of where the standard for breach lies. It is quite at the opposite end of a spectrum of standards of where breach occurs to the deliberately low threshold for opening a Section 47 strategy meeting. Fourthly, the judge's self-directions vis-a-vis where the standard lay were themselves sustainable, unimpeachable. He referred to TDT, and it's in TDT that we see the quote from Lord Dyson from Rabone, which you've already seen.
About the negligence thing, that one.
Absolutely, my lady, but not just the fact that it's more difficult to breach the operational duty than mere negligence, but also his statement that the test is a high one and more stringent than the test for negligence. So,
just remind me where this passage is.
It's at 44 of TDT, my lord, and 37 of Rabone. Rabone's on page 400, I believe, of the authorities fund.
I go to TDT. So, paragraph 37 of Rabone, as quoted in paragraph 44 of TDT. Lord Dyson says, I accept it's more difficult to establish a breach of the operational duty than mere negligence. This is not least because in order to prove negligence, it's sufficient to show that the risk of damage was reasonably foreseeable. It's not necessary to show that the risk was real and immediate. Now, if that were the only reason, that doesn't really help you, does it? Because we're not concerned here with the distinction between damage being reasonably foreseeable and risk being real and immediate.
No, we're not.
So you have to say, and I suppose you're supported in the fact that Lord Dyson refers to the test as a high one, but you have to say that the test is distinct from the negligence test for reasons other than that particular reason that Lord Dyson is picking out.
Yes, it's not just about how soon will it be upon you, reasonable foreseeableness versus imminence, say. It's more than that, and we see that from, one, the fact that he describes it in broader terms as a high one, and also the fact that he says, not least because. So it's not exhaustive of his reasons for so thinking.
No, he doesn't give another reason.
No, but you will, I expect.
But you're taking us here, are you, because you want to make the point that the gravity, if you like, of what's engaged in Section 47 is of a different order from the gravity of what's engaged when you're talking about a convention breach. It's a step change. It's something along those lines, is it?
Yes, my lady, we would be perhaps have better suited facts to compare that point if we tested the difference between negligence and the protection duty. That might be seen to be a substantive duty and a substantive duty, perhaps, but we have instead something quite distinct. We have a Section 47, not just the common law standard, the particular thing that my lady will know about negligence and where it's applicable and the standard and its flexibility and so on, but a precise additional protection that Parliament has created because of the issue, child protection. And Article 4 is the other side of negligence, if you want to put the three in a row. Article 4 is one of our core convention rights. We've seen the cases where breach is found. And my lady has pointed out the distinctions, and I'll address some others.
Now, I mean, could that be spun the other way? So that one would say, well, look, if this is such an important thing to achieve, keeping people protected from modern slavery, then actually the standard, the duty of the local authority should be higher rather than lower.
I would perhaps accept that, my lord, in terms of when the duty is engaged. And to reiterate, the judge found it was. But in terms of finding what was necessary, what was reasonable to discharge it, that I would submit that Rabone is evidence for a greater degree of default being necessary, rather something more like Rantsev and other authorities that I'll come on to. In fact, it may be worth touching on some of them now. Killich was one, for instance, you were taken to. This was tab 20 and at paragraph 65. Page 815. That the court notes that Kemal Killich made a request for protection to the governor just under 2 months before he was shot dead by unknown gunmen. So the analogy here would be of a request for protection of the authority, a failure to notify the NRM, a failure to put in place the accommodation and the whole other package of support that kept him on the road to where he is now. But I don't want to go into post-decision evidence, but the point is that they were seeking to provide him with education and therapy, and there was an issue of engagement. But the contrast is key.
And that's what you really rely on, is the material of all the support, practical support that was being given at the time, and that at the time of the judgment for the material bits, it appeared to be working.
Absolutely. We touched on the statutory assessment there. A point that we should have picked up whilst we were there for efficiency's sake is that after that section on, I may have to look at it again, but I've still got it here so I can tell you. Under the heading of safety.
Sorry, you going back to the 4th of February?
I'm afraid.
No, don't worry. Yeah. You just said that I know where I am.
Yes, so that was 19 and 20 of the bundle, supplementary.
Yeah.
But then see what comes thereafter. It is a rationale that we need to keep this provided, because the whole purpose of this assessment was, should we carry on treating him as a looked after child with all Part 3 of the 1989 Act revisions? I won't read it, and I don't want you to take up time now reading it, but from that point of that section that you did read, safety, onwards, through to the heading, what's the harm that's been suffered, what are the risks to him, social workers' analysis, all the way through to the summary in the paragraph at the bottom of 23. In summary, it's my professional view that the current placement meets the appellant's immediate needs appropriately and remains a protective factor in his journey towards independence, as well as during the application process with the Home Office. All specialist and basic support is in place, and as much as can be realised under the circumstances and depends on the appellant's engagement with the respective professionals, which is less than forthcoming. And then over leaf 24, final paragraph of that box, without the current levels of support, the appellant could be at risk of criminal exploitation, aggressive behaviour leading to further criminalisation, etc. And they take into account, they don't rely on, oh, he's not engaging. They say, in fact, due to his own lack of consent and engagement, he remains at risk of his psychological and medical needs not being met. And then the manager reviews it, and that's 24, 25. And at the bottom of 25 refers to the protection and support offered by K2 and local authority staff. K2 is the accommodation which provides him with furniture, equipment, utilities, promotes his well-being, including making referrals to relevant agencies, etc. That's set out in the penultimate paragraph in 24. So it's not just for the cheap fact that they actually use protect and protective and protection, but it's the nature of this provision. And so whilst it might not have been enough for us to succeed in respect to the extremely precise Section 47 duty, it is well enough to establish that there was no breach of the very substantive, very practical and effective Article 4 protection duty.
So how do you answer in terms, the case that's made against you is that however much you did and however good it was, there were two things more you could have done. You could have contacted the police and you could have contacted the national referral mechanism to say, do you know anything about this man?
On the facts below, which, as I pointed out, we're not cross-appealing against, those are found to be defaults vis-a-vis, certainly such as to mean that we don't escape finding of Section 47 breach. We say that those omissions, which the judge is fully cognizant of, because he found them to amount to breach, they don't amount to Article 4 breach, because there is a different standard, one. Two, they, if anything, represent an investigative duty breach and not protection duty, insofar as that applies to local authorities as part of the picture. Three, because the police are already notified, and the police, as was considered at this morning, are already in relationship and contact with the respondent and the Gloucester Council.
How do we know that? Because I put that specific point to the appellant, and they said, well, all you can see is a reference to June 2019.
I base that on, my lord, the fact that in the 2019 meeting, where there was the finding of there's no evidence of it, they were all present. Mr. Asmar was present, the police were present.
But so we know that they were there in June 2019, but what about February 2020?
With February 2020, hence the finding below, there was no reconvened Section 47 assessment. At it, the police would have been present, I expect.
But that's what he says is
Yes.
why you're in breach of Article 4 as well as Section 47.
Yes, my lord, but
And your answer was the police were there, but you now accept they weren't there for the 4th of February.
yes, my lord, I'm not saying they were there in 2020 February. I'm saying that given that they were already in contact regarding this very individual, they would have notified, it's the reasonable inference, had there been further news, which is already to wonder why the local authority, who are assessing him all the while via ongoing statutory assessment duties, which is an ongoing duty, informed by the agency providing the accommodation and support, would know it already, but it demands the finding that the police somehow would one, know more, despite the fact that they didn't even feed into the SCA's decision, and two, would have sat on their hands and not told the local authority, and three, let's recall what was pleaded in the amended Statement of Facts and Grounds, failure to notify the police so that they could perform their investigative duty, but they were told directly.
It doesn't say that, does it? I was just looking again at that. I've forgotten what page.
199, my lord, paragraph 15.
I'll get there eventually. I'm not sure it's 199.
Of the core.
Oh, core. I'm looking in the wrong bundle. That would account for
That was the amended pleading, yeah?
Yes.
That was the one that came in very
So
late.
if you look at paragraph 15, it isn't so that the police can do their duties, is it? So that they could seek the help of the police.
Perhaps I'm distracted by the subclause, the pursuant to the police's own Article 4 duty to investigate.
Yes, I mean, I see that, but it definitely refers to seeking the help of the police.
Yes.
Yeah.
Then we get into the perhaps hot water of the materiality of that and what extra information they had, etc.
Well, it's said against you, rightly or wrongly, and here's your chance to answer it. Well, even if the police had nothing, that's a breach of Article 4. What's the answer to that?
One, that the standard that Article 4 required wasn't breached by that. Two, the domestic policy framework didn't require that. Three, the facts didn't require that. So Article 4 cannot be breached by those circumstances.
One of your answers was the domestic framework didn't require that, but Section 47 did. That's why you were in breach.
Section 47 required the opening of an assessment, a strategy meeting, which is to consider whether to pursue Section 47 inquiry. That is not about seeking the help of the police per se. I mean, they would have been brought in as part of it, but I mean, maybe it is the same thing, but I would submit that that low threshold for opening up that inquiry, that multi-agency approach, does not represent an equivalent standard. It cannot be imported. It's not equivalent in relation to the Article 4 protection duty.
So that's your key point on the law, is that it's a different standard.
Absolutely, yeah. Different standard, different duty. One is protection. I take my own friend's attempt to say that the protection duty is also a duty of inquiry, but we are then in danger of, despite this demarcation and despite the strenuous emphasis, this is about the third of those duties, or I think it was the second of those duties that was said in the skeleton, merging them and submit that that is not possible. And sorry,
I was just going to say, if you're looking at the protection duty, whatever may have happened in cases where people have gone missing, I suppose you can say that the evidence shows he is still protected.
Quite, absolutely. I mean, the protection that can be arrived at via Section 47, Part 5 of the Children Act, is, as you were taken to, the emergency protection order. And if my lords, my lady, have done any family law earlier on, perhaps will know about this. This is the bread and butter of those instructing me. That would have been irrelevant here. These are points I've made in my skeleton better than I perhaps will make now orally, but that enables the removal of the child from the harm and to then accommodation, or preventing them being removed from, say, a hospital by someone who wishes them ill. Here, via Part 3, Section 20, etc., is already accommodated, etc., and therefore delivering on all that Article 4 required. To make inquiries of the police cannot be spelled out of that.
So even if the protection duty can have an investigative element, the investigative element is as part of a composite leading on to a failure to provide substantive help. And here you say, well, the local authority was already providing substantive help and you haven't fallen below the standard.
It may, yes, well, and it may assist if one thinks about where public law's various duties of inquiry are triggered. It tends to be where something happens that triggers it. Here, nothing occurred that put them on inquiry as to needing to find out more information. And so unless it is the case, despite what I'm saying about Article 4, that there is this very specific upon notification, and certainly it might be thought now it prudent by local authorities upon notification of conclusive ground decision, make sure you convene a Section 47 assessment, make inquiry of the police, or you're at risk, by default, automatically, then there's no requirement to do so on these facts. It was the authority that had all the information already.
I mean, I suppose it might alternatively be said, well, the trigger was finding out what the authority had decided. So that's the trigger to go and find out why.
I do not recall whether the reasons were supplied. I don't think they were. I don't think they were told we made this decision simply on the basis of what you were told. So I can't say they knew that there was nothing more to seek. But I do maintain that it wasn't necessary as part of a protection duty to make contact with the police in response.
Yeah.
I mean, I do think your lodestone is some of the instances of where breach is found in the Strasbourg authorities.
Well, you're certainly entitled to say that Strasbourg looks at the actual reality of what occurs rather than theoretical breaches, etc.
Absolutely. And we looked at, was it Killage, beg your pardon.
You say the sorts of things you see in those cases are so different from what we're concerned with here.
Absolutely. For instance, in relation to Ransev, let's come on to that judgment, including the point made by my learned friend who looked up and obtained from Hudoc the actual domestic provisions, which is actually quite helpful to the respondent. So if we go, Ransev is at 23. I apologise for going back over authorities, but we wish to draw from them. 298, paragraph 298. So this essentially is the findings of breach, 3 of them. First is failure to make immediate further inquiries into whether Miss Ranseva had been trafficked. the equivalent here would be failure to refer to the SCA. Secondly, they did not release her, but decided to confide her, strange phrase, to the custody of MA, who is the trafficker, essentially. The equivalent here would be, I mean, it's obvious. Thirdly, and this is the point my friend relied on, no attempt was made to comply with the provisions of Law 3.1 of 2000 and to take any of the measures in Section 7 of that law. So the first point before we look at those domestic provisions again, this is one of three considerations. And it's important to note that this does not represent a principle that somehow breach of domestic provisions can then sound in Article 4. But if we look at those domestic provisions, and that's Section 7 that they mention as their third reason for finding breach, 298 of the judgment, if you still have the
Yes.
paragraph 130, Section 7 imposes a duty on the state to protect victims of trafficking by providing with support, including accommodation, medical care and psychiatric support. We did all of that. So I think this is a point made by Lord Justice Dingemans about how you were talking, my friend was talking about all these supranational jurisprudence. But ultimately, the Convention seeks to ensure that domestically there is already provision. And that is what is the relevance of this here. Is that they are looking by means of supervision at the domestic provisions about whether what was done already was, what was required already domestically was discharged. And we say it was done here. And the fact that as part of the armoury of protecting children, there is also this high power Section 47 power, and that wasn't done with its very low threshold saying, if you find, I forget what the exact threshold is, you have the provision, you must conduct, at least look into this, doesn't mean that there was failure to satisfy the protection duty by the other statutory duties that were discharged. It's also important to note that, that we are looking back at what the judge found ultimately, and he took into account this fact that the statutory guidance is very precise as to the particular nature of the Section 47 duty and when it's engaged. And he relied at his paragraph 63 of his judgment on that fact. He said that his finding on Section 47 influenced by statutory and non-statutory guidance. And he set out that guidance at 32 of his judgment, and been taken to it, and it shows how low the threshold is. The next point, I'm afraid I've lost. I no longer give you numbers. Is the damages point. It was essentially conceded or confirmed, however you want to look at it, that that is what this is about. And certainly that was what was said at first instance, as the judge noted. Paragraph 54 of the judgment, 38 of the bundle, core bundle. This, I don't want to be a hackneyed respondent authority advocate saying, about talking about snowballing and so on. But for good reason, breach of statutory duty simpliciter X and Bedfordshire, statutory duty doesn't give rise to amount to a cause of action, and an additional cause of action is necessary. It is very hard to see how, if on these facts, where the local authority strenuously seeks to provide, at no point fails to wash their hands, at no point fails to refer to the NRM and engage that process, which in turn further notifies the already aware police, then in every case of Section 47 breach, you are going to have this as part of it. And the particular risk of this, and why I say this is not sort of a scare story, is the courts may have come across cases where parents are challenging the intervention in their lives of the opening of a Section 47 investigation, which gives the social worker nuclear powers to essentially have the door broken down and have access to assess the child. And if the threat of Article 4 damages hangs in the background as somehow coterminous, then it's going to be utilised in far more cases at a trigger threshold that is palpably not the threshold demanded by the authorities. And perhaps to make it less such a hackneyed point, let's go back for our second of 2 points to be drawn from A and the Criminal Injuries Compensation Board. Page 1116 of the updated authorities bundle. My Lord Justice Dingemans, the paragraphs internally are 29 to 31.
Thank you.
Page 3759 of the report. Ms. Kaufman places particular emphasis on the closing words, which she submits are a recognition of the court that there is an obligation on states to provide compensation to victims of trafficking. I am unable to accept this submission.
Sorry, I've lost.
Oh, sorry, my Lord,
Which
didn't wait long
paragraph are you
enough.
reading from?
This is the very top of the page.
Oh yes, I'm sorry. Yes.
Which paragraph are you on?
28, where it sort of overlaps into the page 3759, beginning Ms. Kaufman, page 1116 of the authorities bundle.
Got it, thank you.
And then at the bottom of 29, in even stronger terms, had it been the court's intention to recognise such a duty, such a development in the law would undoubtedly have been given considerable prominence. And similar point in relation to SM and Croatia at the bottom of 30. So we say that even if Article 4 breach could be established, it does not follow that there is a right to damages following from that. And if there's no duty on the state by Criminal Injuries Compensation Board, say, to generally compensate for trafficking, then there cannot be a liability and damages on a local authority that is certainly not responsible for the trafficking, but is seeking to do its bit locally via its duties to protect them. So it's somewhat futile to the extent that this appeal is about seeking damages and a springboard for the same. It couldn't succeed anyway. So we really are in the position of what is the point of this appeal? What does it add?
And what about the questions that were raised at the start in relation to whether you can convert domestic breaches which overlap with convention rights into convention rights every time? And the authorities which suggest that you look at domestic laws and don't need to go and shouldn't go to the convention.
I'm with your lordship on that point. They, not just because Article 4 has a systems duty, which would demand creation of the sort of framework we see via the NRM and specific duties imposed on all in the area to be trained in the issue, and the Palermo Protocol with its requirement that law enforcement agencies be trained, etc. But the same point regarding ensuring standards are met domestically to achieve compatibility ultimately by Section 6 of the Human Rights Act with that international law means that it's contrary to the point of bringing it home to add it on, to tack it on. One, because that is ultimately the work of the common law in doing so. It's not because of Strasbourg has said it. It'd be you saying, we feel the need to fill this gap. And yet there's no need for it. So it would be a sort of theoretical point that we need to ensure that the two keep in step, not because we have deficiencies that need to be upgraded, but because ours is the stronger, as often happens. So false imprisonment law is found by the Supreme Court to be stronger than Article 5 law, for instance. Well, to the extent that we can draw any analogy between these quite distinct duties, there's no reason why as the judge referred to, that the domestic law often provides greater protection, that you need to do the job essentially of Strasbourg and strengthen the Article 4 provision beyond the level that they themselves have produced. That would be very strange. If the claimant wants to go to Strasbourg and say your jurisprudence is missing a trick and you need to find that Article 4 breach happens in these circumstances because they're failing to recognise that domestically, then you can do so. But it's not for this court to update those standards. Indeed, the Human Rights Act requires that the Strasbourg jurisprudence be followed, essentially, unless there's good reason for not doing so. And Strasbourg hasn't gone this far. It hasn't gone anywhere near it. Now, just going to pick up some of the points on this ground before I turn to ground 1 and the description of the roles ground. So sorry if the points that follow seem a little bit scattergun. They're just to pick up with points made by my learned friend. This was in relation to the Ransev points about the relevance of breach of domestic legislation. And reference was made to Articles 5 through to Article 1, Protocol 1 having a variation on prescribed by law. Article 4 does not. So it goes nowhere. And it would be very strange if, one, there's no qualification to afford justification anyway. But if it was somehow founded on the fact that domestically forced labour were lawful domestically, it would be extraordinary. I believe I've actually covered most of them in my positive case.
We bounced you around quite a lot.
Yes, I've actually picked up most of it,
so
just
I can understand
to the good, because I can't read my own handwriting.
Dealt with these points.
Oh, TDT. This is back on breach, because I must underline ground 2, which I'm still on, is about breach. It's not about duty. So TDT, which is tab 14 of the authorities bundle. You may recall this already. It was on page 480.
And you say this is primarily about duty, not breach.
Beg your pardon?
You say this case is really about duty, not breach.
It is, but it does give you some. It is somewhat instructive.
Yeah.
I put it as low as that. Put it conservatively in relation to this issue also. So 480, so 4951 report. You looked at paragraph 83, top of the page. And this was attempt to rely on the statements as to from Osman and Rabone regarding an unduly burdensome obligation shouldn't be interpreted as such, which is worth my stressing it as well, because it goes to my point about the height of the duty. But in that case, it was said, or Justice Underhill said, that's fine. He says, as general propositions, all that is unobjectionable. But what specific obligation it is proportionate to impose depends on the circumstances of the case. Mr. Lewis did not argue, nor sensibly could he have done, that the particular protective measures sought by MG in this case, essentially that the claimant should only be released into safe accommodation provided by the council, which it had agreed to provide, imposed any disproportionate burden. Well, again, the accommodation was provided here, and much more. Secondly, in the same paragraph, the argument is in truth an unattractive one in circumstances where the claimant's release was apparently not the result of any considered decision-making by the relevant Home Office team at all. Contrast NRM referral that led to this whole business. The renewed, maintained Part 3 of the Children Act protection with not just, fortunately and coincidentally, but with a view to protecting him from the risks. And this is particularly a key part of the judgment. So my learned friend says this is the key domestic authority. Well, I borrow from that because at 85, I regard it as reprehensible that once MG had put the claimant's age squarely in issue, no attempt was made by responsible Home Office staff to reach a considered view on the question. So a complete absence, and compare, because you can draw a single, helpfully for the law and its coherence, line with the Strasbourg authorities, where the failure is to do anything, which is consistent with me saying that there's a high bar for this. And if you get into the territory of, well, they did quite a lot really, but you say that there are certain niche steps that they didn't do, which might be sound in a very particular high-power domestic duty, but don't mean that there is breach of the Article 4 standard. I move on to ground 1. So the starting point with my oral submissions, forgetting what's been said in writing, is that in relation to my lady's point about, are you sure this really is not just a description of the respective roles? How much is it actually bearing upon the conclusion? It's a comment, and so on. And my learned friend's response that, well, if that's all it is, then I take no issue with it. So if that is the case, that's the end of ground 1. But in case it's not, more can be said. And the first point to be said is that this requires some forensic, perhaps attention to what was actually said by the judge, if it's going to be sought to be impugned. So the ground is the judge erred in concluding that the respondent was entitled to regard the police and the SCA as the agencies principally concerned with the Article 4 protection duty owed to the appellant as a child victim of trafficking. What the judge actually said is that the defendant would be entitled to regard the police and the SCA under the NRM as the agencies principally concerned with both the operational and procedural duties owed to the claimant as an actual potential victim. So several points have to be highlighted here, essentially to frame this challenge and bring it down from the more egregious formulation in the ground. First, the judge said would be entitled, not was entitled, much less did regard. Accordingly, irrespective of the merits of what he said, which I will say are sound, it was effectively obiter. Secondly,
can one say it's obiter when it's given as a particular in relation to the previous sentence? I mean, it opens in particular.
Perhaps not, my lord, but the use of would be without reference to them having done so. But I take the point that perhaps it's in his head and maybe it's poisoned his thinking. It's something he clearly thinks is the case, whether it was part of facts in the decision making or not. Secondly, however, although ground 1 is stated the judge erred in concluding that, the impugned statement was not his conclusion. As I said earlier, it was the last sentence of his judgment, paragraph 64, but the conclusion is in the previous sentence, which is, I do not find on the evidence before me that the defendant has failed to take reasonable steps in the particular circumstances of this case to discharge its operational procedural obligations in relation to the claimant under Article 4. Thirdly, the judge said, principally concerned with both the operational and procedural duties. So he wasn't just making a point about the protection duty, despite ground 1 saying so.
Well, maybe they're taking exception to the operational part of it.
Part of it, perhaps, but then the appellant would need to say which is referring to which, ultimately, and to unpack it. And to say, for instance, defendant would be entitled to regard the police and the SCA under the NRM as the agencies principally concerned with the operational procedural duties, and say which bit of it, because I mean it's at least half correct. It's the procedural duties are the investigative duties, and they are owned by the SCA and the police. So that is correct.
That's the third heading, as it were, on the subdivision of Article 4 under Rancid.
Yes. Yeah. But I take the point that maybe you can extract that and silo it and aim at it, but it just means that it is not of the degree of egregiousness where there would be a very clear, hard-edged error to say that the police and the SCA are... I won't pursue this one further, I'm probably playing myself up.
I mean, to start where you began, and later Justice Whipple began, it reads all right if you relate it back to what you're recorded as submitting, because you're recorded as submitting as far as the operational and procedural duties are concerned. It's principally the police who have the function of detecting, preventing and prosecuting instances of criminality. So seemingly, the function of detecting, preventing and prosecuting instances of criminality is related to both the procedural and the operational duties.
Yes, absolutely it is. Part of it is informed, as you say, by what I'm quoted as saying, paraphrased as saying, but it's not just that. It's not just talking about the investigative duty. There was evidence before him to support what he says about the operational duty also. The fourth point to emphasise about it is that he uses concerned with. He doesn't say that they are the ones responsible for. Concerned with is more analogous with involved with or occupied with. In short, concerned with, by using concerned with, the judge was not saying that the protection duty is the sole preserve of the SCA and the police.
But he did say principally concerned with. I would have understood if he just said concerned with. I know you didn't draft it.
Principally is the fifth point. Principally is notable. Principally means chiefly or above all. It's not the same as exclusively. And we see some of his meaning in paragraph 53, where, having set out the three Article 4 duties, the judge said, the first is self-evidently the responsibility of the central government and not of local authorities. The second and third, however, potentially impinge on the obligations of the defendant as a public authority. So he cannot be read as absolving it of the protection duty. That's what it actually says, and that is what should be clarified before considering whether any of it is somehow incorrect in fact or quite apart from materially erroneous. We say that it was accurate. If one turns to the Modern Slavery Act statutory guidance, we have a helpful section on the relevant roles and responsibilities of the agencies. It's at page 212 of the Authorities Bundle, tab 8-7. So if we start with 412 and 413 on page 212, it's notable that where it starts, is that the statutory duty at section 52 of the 2015 Act to notify specified public authorities are charged with doing so. They are what's called first responder organisations. That is, if you like, their first duty, because otherwise, for all their local child protection duties, the NRM system won't work if people aren't referred into it. .5, the second point to highlight. The NRM is the UK's framework for identifying victims of modern slavery. So that is relevant in relation to the investigative duty. But then the next sentence also in 4.5 is key in relation to the protection duty. It is also one of the means of ensuring that adult victims receive the necessary support and assistance immediately after their identification as a potential victim. Now, in relation to children, support and assistance is all that we've seen the appellant was provided, and that we say constitutes part of the protection duty, because that is an important part of protection, because one's social circumstances are what makes one vulnerable, essentially. And at 410, public authorities that are first responder organisations, we see description of the respective roles. Under law enforcement, which includes police, I think it's fair to read the judge as referring to law enforcement generally. Why would he sort of exclude the gangmasters authority, labour abuse authority, etc.? have the more detailed description of, the more extensive description of their role in relation to all this. They have responsibility for proactively leading modern slavery investigations, unlike all what we saw in Ransom, arresting perpetrators and raising awareness in their jurisdictions. It also says that their role includes identifying potential victims and making referrals into the NRM, and those are shared by local authorities, if you look at the bullet below. Police are responsible for working with local authorities and healthcare organisations, providers to safeguard children and vulnerable adults. I mean, absolutely. I mean, it's a key function in the operation of this system, this framework, that there be interagency cooperation. So it's not inconsistent with that to say that it is the police and adding it in, well, police alone who have the principal role in relation to the protection duty, because the protection duty, taking our cue on it from, say, Osman and the real and imminent risk and the need to prevent those risks to life, who take that upon themselves. It is the authority who, amidst all that, provide the social support. If you then add in the SCA, as the judge did, and the fact that they clearly own an investigative duty, then he was fully entitled to say that those two agencies, drawing broadly the police within law enforcement, are the ones principally concerned with the protection duty. But as I keep saying, it's immaterial. So it's quite important to say, because my learned friend, for instance, talked about fettering of powers, that in no way is this about whether it's in the judge's description, which is principally and not to the exclusion of, because he even said that these duties can impinge on local authorities. It's not about one or the other, and somehow therefore fettering the authorities' powers. There's no danger here of the appellant being left high and dry and having the local authority wash its hands of it. He's still provided for as a former relevant child, being moved to accommodation in Gloucester as per his wish. But there is progress, I'm told. He's taking part in an English as a foreign language course. His engagement is better, and there haven't been, I'm told, the complaints about the state of his accommodation. But you don't need to take that into account. The point is, there has been at no point a failure pursuant to, say, a discretionary power, domestic discretionary power. We will not accommodate you, such as needs to be propped up by a finding of convention duty. Because this is not an authority doing that, and this is not a statutory scheme that needs supplementing. Section 47 is as strong a set of duties, a duty as can be imagined.
And what about the complaint, the final complaint, I think, that is made, which I'm not sure you've dealt with yet, which is that there's still been no reference to the police?
One that is particular to its time. If there were some fresh risk arising by the various people assisting the appellant, from Garras to litigation friend to lawyers, then you can imagine that this team would be pretty on it in terms of demanding a Section 47 assessment be open, particularly having found...
Well, he's not a child anymore.
But they're equivalent in the Care Act, safeguarding duties. And the former relevant child obligations involve the same consideration of risk. It's not it's all over now, I have to bring this because it's my only way to get it.
Thank you.
And in relation to why is there still no referral to the police, the same points that I make in relation to the period then apply even more strongly now, unless it can be pointed to that something subsequent happened. So if at the high point, notification, contrary to your at least middle of 2019 view that there was no evidence of trafficking by the SCA that there was, that is surely the high point. But since, if Article 4 didn't require it then, it certainly doesn't require it now. So it wouldn't make any sense to say there's still no duty. I mean, we're talking about very specific. For all I take my learned friend's point about you can't consider the Article 4 duty once it's there ceases without fresh assessment. We are talking about a very time-specific duty. Hence the point about from Rabone and the imminence of it rather than reasonably foreseeable. It has to be about to happen. So if that is our duty, it would be quite artificial to say, oh, but you've still not done it, because why would it be necessary to remedy something that temporally specific a year and a half later? I mean, it'd be a real waste of the judicial review powers to require the authority to contact the police when the police haven't contacted them, there's no new news of it, etc. Just lastly, so those are my points on what the guidance says. Then there is also which I can deal with quite briefly, the authorities and what the light that they throw on this question of whether protection duty is, and the operational duty is something that principally concerns the police and the SCA. So in Ransev, it was said at 287, page 1007 of the authorities. The point, and this was in relation to the context, that chimes with the Rabone principle about you can't interpret this as imposing an overly onerous duty. What they said is, bearing in mind the difficulties involved in policing modern societies and the operational choices which must be made in terms of priorities and resources, the obligation to take operational measures must, however, be interpreted in a way which does not impose an impossible or disproportionate burden on authorities. And then at 296, also Ransev, which is authorities 1010. In particular, so this is where they're talking about the Palermo Protocol, which, if you like, colours some of the, though it's not been found that they are the same, colours some of the Article 4 duty. In particular, under Article 10 of the Palermo Protocol, states undertake to provide or strengthen training for law enforcement, immigration, and other relevant officials in the prevention of trafficking in persons. In the court's opinion, there were sufficient indicators available to the police authorities against the general backdrop of trafficking issues in Cyprus for them to have been aware of circumstances giving rise to credible suspicion that Ms. Rantseva was or at real and immediate risk of being a victim of trafficking and exploitation. Accordingly, a positive obligation arose to investigate without delay and to take any necessary operational measures to protect Ms. Rantseva. 297, it continues, I won't read them all. It appears that the police did not even question Ms. Rantseva when she arrived at the police station. The police made no further inquiries. It's all about the police. 298 continues. In the present case, the failures of the police authorities were multiple. Secondly, Lady Hale in MN Pakistan at tab 15, it is discernible that there is a view there that it is the police who are principally concerned with the protection duty. This is at 494 of the authorities bundle. And this is referring to the case of J in Austria, which is a case where no breach was found, and her ladyship said, described it, saying that the court decided that the authorities had done all that they could reasonably expected to protect the women. You may want to just note it and look at it yourself, but it talks about what the police did. such as led to the finding of no breach.
I mean, I suppose a lot turns on the facts. There are cases where
Yes.
if anybody's going to be criticised, it's the police.
Yes, and others.
And there are
perhaps the
others where that
authorities.
isn't.
Perhaps, yes. And this is not about, and the judge did not find authorities couldn't come under this duty. It's very fact specific, as he said. Unless I can help you any further. Those are my submissions.
Thank you very much, Mr. Sporey. Mr. Butler.
I'm so sorry to ask. I know that we're running very late. We might rise for just 2 minutes. I will undertake to complete within my allotted time.
Yes,
I'm so sorry to
let's
ask.
do that.
Please.
I'm very grateful, thank you. Could I just deal briefly with the single competent authority file? It was suggested that that was requested by the local authority in response to the way in which the judge had conducted the hearing below. In fact, the local authority requested that file 12 minutes before the start of the hearing. And just to give you the reference to that, it's core bundle, page 115, paragraph 5.1.
Sorry, you're going to have to give that to me again in just one moment. Just hang on one moment.
Sorry.
Yes.
Core bundle, page 115, paragraph 5.1. There's a reference in my submissions below to the timing of that request. And as my Lord Justice Dingemans pointed out, there's no respondent's notice in relation to this material. But I would just make the point, without detracting from my submission that it shouldn't be admitted, that if it were admitted, this material might be thought unhelpful to the local authority, because the failure to consult the police about those named traffickers might be thought to be quite a significant failure. Can I then deal with the point about Rayburn and the passage that my learned friend took you to in TDT? It's Authorities Volume 2, page 467. Sorry, tab 14, page 467. And as my Lord Justice Newey pointed out, what Lord Dyson was dealing with at paragraph 37 of Rayburn was the threshold for the duty being engaged. And that's clear when one looks at the final sentence at paragraph 37. But to say that the test is a high one and more stringent than the test for negligence doesn't shed light on the meaning of real and immediate. That's what he's dealing with. And in my submission, the observations about the height of the threshold for engaging the duty can't properly be converted into a different proposition, namely that the all that is reasonably expected threshold or requirement is somehow higher than the standard of care and negligence. Nothing to that effect in Rayburn or TDT. At times, my learned friends appear to suggest that the threshold that should be applied to Article 4, the Article 4 operational duty, is whether anything was being done by the state body with responsibility. And if, so long as some things were being done, well, that was all right. But I come back again to the submissions I made in opening, that all I invite this court to do is to apply the Osmond test. Now, my learned friend said that the practical support seemed to the local authority in February 2020 to be working. Well, that might be right, but only on the mistaken hypothesis that there was no point in asking the police anything further. And the judge held, and there's no cross appeal against this, that had the police been asked, that might have made a difference. It might have made a difference because it may have resulted in better protection. And that situation is not dissimilar from the position in Killage, where the government said there was nothing that could be done to protect a journalist. And the European Court of Human Rights said, well, you can't say that when you didn't inquire into the risk.
What about the point that all these are fact-specific cases and it's difficult to draw out dicta in the way that one might as a common lawyer?
I do accept that, my lord. I accept that one can't try and transpose fact-sensitive determinations from Strasbourg into domestic cases. But what one can do is derive from Strasbourg's analysis of the facts in a case certain principles. And there are a number of cases dealing with damages where the House of Lords and the Supreme Court have said it's not always easy to derive principles from Strasbourg, and one has to do it in a relatively broad way rather than searching for clear articulations of principle. And so in my submission, one can draw certain principles from the Strasbourg cases in the way I sought to do in opening, And one instance of that is to identify that as a matter of principle, Strasbourg is prepared to say that a failure to inquire is capable of amounting to a breach of the protection duty. My learned friend said that the police presumably would have contacted the local authority if they knew anything of significance. Well, that submission, we respectfully say, is contrary to the judge's findings below. He found that in relation to section 47, the failure to contact the police was material. It's not, we say, now open to the local authority to gainsay that finding. The steps that were reasonable, in my submission, have to be assessed in light of what was known at the time. It can't, what was reasonable can't depend on a post hoc analysis of whether taking the steps would have made a difference. And I say that because that would be inconsistent with Sargentson. It would be to impose a causation requirement. So it has to be judged, what's reasonable has to be judged on what's known at the time. And then could I pick up a proposition that was posited by my Lord Justice Newey? To say that a failure to inquire is only relevant to a breach of the protection duty if it's part of a composite, that is a failure to inquire and a failure then to take practical steps. Well, in my submission, that's not what the European Court is doing in either Rantsev or Killage. It's not saying the failure to inquire in combination with, it's identifying that as a discrete factor which gives rise to breach. But moreover, could I give a principled answer, which is that to say that a failure to inquire only gives rise to a breach as part of a composite would risk the duty becoming theoretical or illusory rather than practical and effective. Because a public body would avoid the protection duty by not making any inquiries. It would, in effect, permit a Nelsonian defence. Now, I made it clear in my skeleton argument that we no longer seek damages. In respect of my learned friend's interorum submissions on damages, that it would give rise to a route to damages for breach of statutory duty, we say, well, no, because Section 8 of the Human Rights Act provides that the court can't award damages unless in all the circumstances it's satisfied that that's necessary to afford just satisfaction. So if it's not necessary, there can't be an award. But if it is necessary to award damages to secure just satisfaction for breach of Article 4, it's difficult to see any policy basis for objecting to an award of damages in those circumstances. Has Strasbourg gone so far as I asked the court to go? Well, yes, because all I'm asking for is an application of the Osmond test. Does it matter that there's no factually analogous case yet decided by Strasbourg? Well, clearly not. That's not what keeping pace with Strasbourg means. And just to underscore that point, could I ask you please to turn up Raybone in Authorities Volume 1, tab 11, page 420. part of the judgment of Lord Brown, paragraph 112, he says, nobody has ever suggested that merely because a particular question that arises under the Convention hasn't yet been specifically resolved by the Strasbourg jurisprudence, domestic courts can't determine it. In other words, it is necessary to await an authoritative Strasbourg decision more or less directly in point before finding a Convention violation. That would be absurd. And I would respectfully submit that Lord Brown's talking about principle, and that applies a fortiori to factual analogies. I don't propose to, I'm almost finished, I don't propose to say very much about who is principal state body responsible, but could I just observe that in J in Austria, well, that concerned a different domestic regime under which it appears the police were responsible for providing practical support to adult victims. It's not really analogous to our situation. And then finally, as to enduring concern, well, doesn't assist the court to determine the question before it, but I understand why it's a matter the court has inquired into. Could I just make this point, that my instructions are that we have repeatedly pressed for a risk assessment and for liaison with the police since the hearing below. And we haven't been provided with a risk assessment which addresses trafficking or which discloses liaison with the police. Now, as I said in opening, clearly I can't invite the court to make any facts on issues of that kind, but I just don't want the court to be left with an erroneous impression that this is now of no concern to the claimant. Could I just turn my back for a moment, please? Yes, I can see that those are my submissions.
In which case, thank you very much. So thank you both very much, and those behind you. You won't be surprised to know that we will be reserving our judgments. As you would expect, they will be provided to you in draft for you to correct typing, grammar, and such like things, but not so that you can re-argue the case. I think in accordance with current practice, hand down will be remote, but even were it not to be remote, there would be no need for anyone to attend. And again, as you would expect, we would be grateful if, once you have been provided with the draft judgments, you seek to agree an order dealing with consequential matters. If there are any points on which you don't agree, could we please have brief written submissions, and we would expect to settle points in the order that we make. So thank you again.
Sounds good.